And just since I'm up, the question of, I guess I'd call it the more than one overt act being alleged, more than the jury seeing more than one overt act. I mean, the logic behind that is kind of topsy-turvy. If you think about it, there's nothing that requires the state to plead the barest minimum in an indictment. And in fact, generally to do so, we would draw a wave of special demurs. Even with this indictment, we drew special demurs with as much detail as it has.
At this point, they're not any longer challenging what you put in the indictment. They're saying whether it's in there or not, it shouldn't be out with the jury for their consideration.
Well, that comes down to if I understand correctly, an argument that there's not sufficient.
Okay. He's referring to a special demur. So let's just quickly go through what that is exactly. Let me just check here. Dun, dun, dun. And let's bring it up. Demur refers to making a pleading that challenges the sufficiency or adequacy of pleadings of another party. Demur typically come in two forms, general and specific. A general demur challenges a broader problem with a pleading that affects all of the claims brought, such as improper venue. A specific demur objects to a particular problem with the details of a pleading, most commonly the failure to claim sufficient facts for a cause of actions. In ruling on yada, yada, yada. So the demur from the defense here is that the prosecution didn't bring jack crap to trial. It is so bad. And that is what Mr. Floyd is arguing against here. Now, Judge Whitaker, when it comes to the directed verdict, has to look at everything in the best possible light for the prosecution. It sounds like a wee furry animal to me. Yeah. Oh, the demur is living in the Congo desert. It's a squirrel. No. So that is today's little legal lesson here. Okay, let's go. Let's get back to this.
Evidence for the jury to find the defendants acted knowingly and willfully, and that is clearly present.
Oh, no. I think we're interweaving
I'm sorry.
different issues now. I thought you were moving on to the issue of whether overt acts that aren't within the 5 years.
And indeed, I am.
It was definitely okay to put them in the indictment, whether they should go out with the
Yeah.
jury.
Okay. I understand.
If you weren't, then bring me back to what
No, I
you
may
were
have
talking
ground the gears a little bit on that one, but I think I just want to make sure you don't have any more questions about the knowingly and willfully issue. And if you don't, then I'll move on to that question.
Okay.
If I understand the logic chain from the defense, it is basically we only have to prove one overt act within 5 years of the day of the indictment. Therefore, anything else is, I think the term was used, surplusage. That doesn't fit the definition of surplusage. And then with particular emphasis, they've said if it's outside of that 5-year window and then would not be relevant to prove the timeliness of the indictment, that then particularly the jury shouldn't hear it because it's confusing, et cetera. I'm aware of no case that has accepted that argument. And it shouldn't be accepted because the allegations are relevant. They show the existence of the enterprise. Right? This begins a long time ago. The state is not precluded from charging or presenting evidence that shows this enterprise has existed for a long time. I mean, at the kind of the extreme level of this, there are federal RICO indictments involving the 5 families in New York that discuss the entire history and formation of them, going back to the Castle Amorisi War of 1932, I think it is. So they would now span almost a century. That was not irrelevant because it tells you how this enterprise came to be, and it shows the early participation of certain individuals. It shows its longevity, its consistency. I mean, under the law, enterprises don't have to be in operation 24 hours a day. They can have lulls, et cetera. But where they continue to exist, where the people who participate in them continue to acknowledge their existence, that is certainly relevant. And there's not an arbitrary cutoff where the indictment gets trimmed to match the statute of limitations. I'm just not personally aware of any case that's ever done that.
Playing in 1.5. Let's get through this.
Thank you.
Oh, he was done.
Can I respond briefly?
Well, I mean, we're still in the middle of the state's presentation, so yes, y'all both get, since it's your motion, a chance to reply, but not right now.
And here comes Miss Hilton.
Good morning, Your Honor. I'll be addressing the directed verdicts as to count 2 and 49 of the indictment, which are the murder counts. Count 50, 51, and 57, which are the participation in criminal street gang activity. Counts Mr. Floyd, whenever the court's pleasure, will address the general demur as to the participation in criminal street gang activity.
I mean, Mr. Floyd, did you have anything? I mean, I took your argument to be essentially, the knowingly and willfully as it applies to RICO, and then basically apply the same argument with regard to the in furtherance of the gang, with regard to the gang counts. Did you have anything to add to that?
Not really, Your Honor. The statutes are quite similar on this point. Historically, the Gang Act is actually kind of a linear descendant of RICO, that some states didn't want to enact a full RICO. They just enacted a gang statute. We enacted both. They have slightly different elements, but on this principle, there's really no difference.
Thank you.
Thank you.
And then I'll be addressing count 62, possession of a machine gun. And then count 52, 64, and 63, which are the possession of firearms by a convicted felon.
All right, 52 isn't the 133, right?
No, Your Honor. 133 will be count
63 and 64.
63 and 64, Your Honor. So, Your Honor, as Mr. Floyd just enumerated, the relevant question is whether, after viewing the evidence in the light most favorable to the prosecution, any rational trier of fact could have found the essential elements of the crime beyond a reasonable doubt. And that's cited in Evans v. State, 360 Georgia Appeals 596, which is a 2021 decision. And first, we're going to start with count 2, the murder of Donovan Thomas Jr., Your Honor. The state has presented evidence that will be sufficient for a rational trier of fact to review in the light most favorable to the prosecution. Your Honor, we have presented.
Yeah, you really, really need to add that in the light most favorable to the prosecution. Because I'm so happy that isn't the legal standard. But I'm also very disappointed that the judge has so little leeway in granting and dismissing counts in this absolute scam of a RICO trial.
Evidence of the June 10th, 2015 video recorded interview of Mr. Kenneth Copeland at the Atlanta Police Department, which is Exhibit 378, Yankee Echo. In that video, Your Honor, Mr. Copeland discusses a co-conspirator statement of Demekion Garlington, in which Demekion Garlington tells him about the murder of Donovan Thomas, that who was involved, which was Mr. Stillwell, Mr. Kendrick, Mr. Justin Cobb, Mr. Damas, and Mr. Damas McMullen. In that interview, Mr. Copeland speaks of his whereabouts on the day of the murder of Donovan Thomas, beginning on early in the morning hours, and when he eventually meets up with Mr. Garlington at a gas station on Cleveland Avenue. He further tells the detectives that Mr. Garlington told him that those 4 individuals, again, Mr. Stillwell, Mr. Kendrick, Mr. Cobb, and Mr. McMullen, had committed the homicide of Donovan Thomas Jr. He told them about the type of car that they were in, which was an Infiniti vehicle, the location of which.
Oh, hold on. Iceland has blown up again. Iceland have blown up again. Let's see here. If I can find. If it was caught when it actually started. It's always so. Okay, let's keep listening to her while I try to find
There, Mr.
when it
Donovan
actually
Thomas was, which
started.
was the barbershop on 330 McDaniel Street. We then also introduced the August 2015 statement of Quindarius Zachary, which was State's Exhibit 531Y, which Mr. Zachary corroborated some of the same information that Kenneth Copeland provided. He also added the additional information or evidence in that interview, which was Mr. Stillwell and Mr. Kendrick at the condo of Jeffrey Williams confessed to him that they had participated in the murder of Donovan Thomas Jr. Those statements and the detail of those statements are corroborated by certain other evidence that has been admitted. We have the barbershop surveillance video, which at 292 Yankee Alpha through 292 Yankee Delta. That video surveillance showed Mr. Donovan Thomas Jr. outside the barbershop moments before a silver and color vehicle, which was identified in testimony as an Infiniti, drove down the street and shot several rounds of gunfire at and towards the direction of Mr. Donovan Thomas Jr.
Okay, let's break this absolute borefest for something. Oh, wrong one. This one. These are the live cams from Iceland. You see here how all of a sudden it starts to glow. Playing in 2x speed here. Look up here on the left hand. Okay, now boom, boom, boom. Iceland blowing up again. And this is like half an hour ago. It started. Another Icelandic volcano eruption. This is the 6th volcanic eruption in a year in the same area of Iceland. Now, the town near already have been on alert and is being evacuated. So people are okay. People are okay. Yeah, and you see down here on the bottom, you can see, okay, oh, it's really going off now. And this is less than half an hour ago, apparently. Let's skip ahead a bit and see if you can see the actual. Yeah, oh, look at this. Yeah, Iceland and volcanoes are like the Gulf and hurricanes. There will always be one. Yeah, look at the top left there. Oh, it's going off. And on the bottom right. So this is as I can hear, it is a mile-long fissure that has opened up. A mile-long fissure. Jeez, yeah. Yeah, Pacific Rim. Or Atlantic Rim, in this case. Let me see if I can find another one. RUV is almost always good at this. But not today. Ah, there it is. So yeah, this is live. Afar TV has live footage. Yeah, this is photo taken from maybe 6-7 miles away from the eruption. I've seen similar before, and when I flew back from the United States in August, I saw an eruption through the plane window. So this is a mile-long fissure that has opened up. Ah, this is interesting. But folks, we are here for this. I just wanted to break the borefest off with something actually interesting happening. So, okay, let's listen to this for a couple of more minutes. Then let's skip ahead to what she actually has to say about the directive.
We also have the Texaco surveillance video, which corroborated Mr. Kenneth Copeland's statement. In his statement, Mr. Copeland tells officers that D'Amica and Garnison told him that they met at the Texaco gas station, that they switched cars, which he explained that Mr. Kendrick initially arrived in a Pontiac Bonneville, and that the
yeah, as Shako says, is she wearing a bathroom rug? Yeah. Does thy mother know you stole her bathroom rug?
the gray Infinity vehicle met at the Texaco gas station. That was depicted on the surveillance video. In the surveillance video, you see Mr. Kendrick walk into the gas station. You see Mr. Kendrick approach a silver Infinity vehicle. You see both